Will your case get dismissed because you were not read your Miranda rights? The answer to that question is it depends. So the Miranda Rights case is Miranda versus Arizona. And in that case, the court decided not only do you have the Fifth Amendment right against self-incrimination, and you hear people say, I plead the Fifth, you have the right against involuntary self-incrimination. So the Miranda case and the Miranda rights really only come into play once someone is in custody and if someone gives a statement. Now, a statement to police, some people think that's just a written statement, but a statement can be anything that you say or anything that is learned from your conduct during a police investigation. So just because you don't have a written statement doesn't mean that you haven't given a statement. And then there are statements that police write for my clients. That comes about sometimes when my clients are not able to read and write. It also comes across when my clients are too shaken up to write their statement, but I prefer to see statements that are written by my clients if they're able to read and write, because that gives me some indication that hopefully it's their own words and things aren't getting construed and turned around by police. So there is a lot of case law on this topic, and it can't be reduced to one video, obviously. So I'm trying to give you just an overview of the Miranda warnings. They are not required in every single case. They are required in cases where clients or the accused are giving statements. And one of the things that we look at in Miranda cases quite often is, again, what I mentioned, is someone in custody. Now, someone is in custody when the reasonable person would not feel like they could leave. They could walk away from the police. So that basically is the first part of the Miranda warnings. The second part is whether law enforcement initiates questioning or interrogation. And sometimes interrogation doesn't really come off as like what you think about on TV, where someone's in an interrogation room and they're one-on-one with a detective. So it could just be casual questioning, and it could be seemingly innocent questioning, and it does not have to be something that is formal or written. It can just be question and answer format. So let's talk about some things that are examples of being in custody. So it would be in any situation where a person is otherwise deprived of their freedom in any significant way. It doesn't necessarily mean that you are in handcuffs and in the back of a police car. It doesn't necessarily mean that you're in handcuffs and not in a police car. In fact, it doesn't even mean that you are in handcuffs. If you feel like your freedom was deprived in any significant way, a reasonable person would feel the same way in your predicament, then there is an argument that you are in custody. So a second part of that could be a person's freedom of movement is the functional equivalent of a formal arrest. In other words, if you're surrounded by 5-6 police officers, a reasonable person would probably not feel like they could move about, that they could walk away from the situation. Even if you're not in handcuffs, you're surrounded by federal agents or local law enforcement, and you would certainly feel like your freedom of movement is not something that you have much of a choice on. And so again, the person does not have to be in a police station in custody per se. So if you made statements to an undercover officer, for example, and that undercover officer did not read you your Miranda rights, is your case going to be dismissed? Now, there are some situations where a confession could possibly be thrown out or not even used in court, even if the Miranda warnings were given. So there are exceptions to this, but there could be, for an example, a confession after an illegal arrest, and that confession could be thrown out. After being arrested, statements made by someone who was in a state of medical emergency, that is arguably a way that someone could get their statement thrown out even if their Miranda rights were given. Confession made after someone clearly stated they wished to talk to an attorney, and the police ignored this request and resumed interrogation. So if you ask for your attorney during the portion of your arrest, during the time that you're being arrested, you ask for an attorney and the police ignore that, or they don't give you your attorney, and it is during a stage of your case that is a relevant part that would fall under this Miranda exception, then we're looking at something that could possibly be thrown out. And another thing that you could think about, another example on statements that could possibly be thrown out when you have been given your Miranda rights. I'm not talking about the case being thrown out necessarily, but your statements. If the police coerced you or threatened you in any way, or they withheld something from you, like you need to go to the restroom, or anything that would be something that you feel like was a police threat or coercion. So there are some situations where a confession would be admissible and the Miranda rights were given. And in that case, here are a few examples of that. A person waives their Miranda rights. In other words, they are in custody, they have been read their Miranda rights by law enforcement, and they decide they want to go ahead and talk anyway. So that is a way that the statement will stick, possibly, if there are no exceptions. Remember that Miranda does not apply if a suspect is simply taken into custody. It applies only if he is in custody and subject to police interrogation and there is psychological coercion by the police. So keep that in mind as well. Now let's talk about some factors that we look at in determining whether a statement is voluntary. Court will consider the totality of circumstances, but we're going to talk about a few elements, and these aren't all the elements, but these are a few that a court may consider in considering the totality of circumstances. So, number one, did the police coerce a confession while the accused was in custody and being interrogated? So again, the accused has to be in custody and have to be interrogated. What is the youth or age of the accused? If it is a very young person, such as a minor under the age of 18, or even someone over the age of 18, that is a younger person and they may have some kind of learning disability, they don't understand what's going on. We can look at the isolation of a minor from a parent while the minor is in custody during a police investigation or interrogation. And then we'll look at things like, did the police interrogate the person while you were in jail? After you were arrested and you've been sitting for a while, let's say you're not able to make bail or your bond hearing hasn't come up yet, and you're sitting there sort of freaking out, wondering if you're ever going to get out of jail. Police come to you and they take that moment of weakness as an opportunity to take advantage of you in a desperate situation without an attorney, and it puts you in a weird position. But it's done. It doesn't mean that your statement is going to be thrown out. It's just these are some voluntariness statements looking at whether or not these are factors to consider in determining if a confession is voluntary. In other words, were the police taking advantage of your fears of your reaction to jail time? And maybe this is the first time that you've ever been arrested, and you are not the person that's cut out for jail, and the police are trying to catch you in a moment where you're weak and vulnerable. Another thing is, did the police read you your Miranda warnings? If so, what was your level of education? If you are not able to read and write, if you're not able to comprehend and understand the Miranda rights, then that is something that we would be looking into. Especially, and I've seen this, if the accused speaks a different language than as their native or first language, or the only language that they speak is different than that of the police, and the police do not offer an interpreter for questioning, for Miranda warnings. I mean, there's no way that you could voluntarily waive Miranda rights. It would be hard to conceive of trying to waive rights that you don't even understand, that you don't understand the consequences of waiving the rights. And just because you speak a different language doesn't mean that the police should take advantage of that. Police should provide a translator, or at a minimum some kind of translating software, or call into there's a phone number that police can call to get a translator if there aren't police on the scene, or that can be called to the scene that can speak your language. We also would be looking at how long the accused was detained and interrogated by the police. A 2-minute interrogation is a lot different than a 2-day interrogation or a 6-hour interrogation. So obviously, the longer that you're in a room with one or more law enforcement or different law enforcement officers, the more that you may break down. And the police know that, and they may take advantage of that. So that would be another factor that we would be looking at. And then I mentioned this earlier, but I'll mention it again, that was the accused offered food, water, beverage, bathroom breaks? So, these are all things that we would be looking at in determining if a confession was voluntary. Was the accused deprived of sleep during the interrogation? There have been numerous studies on deprivation of sleep and how it affects the human mind, and police can sometimes do take advantage of that. So even if your interrogation wasn't very long, if you had not been sleeping for the previous however many hours, been up that long, and the police are, by their interrogation, keeping you up, keeping you awake, then that would be something that we would look at in these factors to determine if your confession was voluntary. So we've kind of gone over this, but I want to go over it again. If you or if a witness in your case have talked to the police, okay, just verbally talking to the police, and you did not give a written statement, does that mean that that conversation can be used against you? Yes, possibly. It is an absolute misconception that witnesses, victims, defendants that just talk to police and they don't write anything down, that they didn't give a statement, but that's not necessarily true. You can give a statement to the police, the victim can give a statement to the police, the witness can give a statement to the police just by talking to the police, by calling 911, using the contents of that 911 call, or an excited utterance, or there are so many things that can be used for statements that aren't necessarily written statements. So another question that I get a lot is, the police lied to me when I was in custody and being interrogated. So is my statement that I made based on the police's lies, is that admissible? And the answer to that is, it depends, but it is not against the law for police to lie to people during interrogations. For example, the police say that we have your DNA on whatever they say that they have it on, and they don't have your DNA. Because the reality of DNA is it takes many months, sometimes even with putting a rush on things, to get fingerprints and DNA, those kind of things from SLED, which is the South Carolina Law Enforcement Division, which typically is the agency that would be looking at DNA or fingerprints. And you know, it doesn't mean that they don't have your fingerprints, but you know, if they haven't been watching you for several months or more, and they've had time to get this DNA, you know, I'm just using DNA as an example, but you know, you don't have to necessarily believe what the police are saying. And then lastly, I want to go over the actual Miranda rights. I have seen cases where police use like a little card, or they've been a police officer for so long that they have it memorized. And I've seen people who have tried to like wing it, and they get the Miranda rights wrong. So let's go over what the actual Miranda rights are. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and to have him or her present while you are being questioned. If you cannot afford a lawyer, one will be appointed to represent you before questioning if you wish one. If you make a statement or answer any questions, you have the right to stop at any time. And then some people will follow up with, do you understand these rights? Or, having been advised of these rights, do you still wish to talk to me? And you want to make sure that this language is the language that the police officer said to you, not trying to wing it. And remember that once you start, if you decide that you waive your Miranda rights and the waiver is voluntary and it meets all the standards that we've talked about in this video, you still can stop questioning at any time. Like in the middle of questioning, you may be like, that's it, I don't want to talk anymore. I want my lawyer. Police have to stop asking you questions. They can't try and get you to change your mind. Sometimes the police obviously do that, but that is something that can be litigated in a Miranda hearing, or you know, that can cause an issue that is certainly something that could be left up to the discretion of a judge as to whether those statements should come in after you've requested a lawyer or after you've requested for questioning to cease or to stop. So I hope this has given you a pretty good idea of the Miranda law in the United States and the things that we've gone over. I hope it gives you a better idea. Sometimes it's better to listen to what a lawyer has to say about Miranda and the law rather than seeing what's on TV or what your well-meaning friends or family, what they tell you. So if you like this video, please feel free to hit the like button. And if you would like to subscribe to my YouTube channel, please feel free to hit the subscribe button. I'm attorney Susan Williams. Thanks for watching.